Hello, I'm Sandy Dallenbert, and I'll be teaching this course in Florida constitutional law. We also have this styled as state constitutional law, but there will be a great emphasis on the Florida Constitution throughout this course, with some opportunity to look at decisions in other cases. Our objectives in this course are to learn about state constitutional law, but today I want to begin with the federal constitutional law principles that you've already studied in your course in U.S. constitutional law, because those will give us some of the boundaries of our study in state constitutional law. What powers are given to the federal government and what powers to the state government? And those are largely derived from a review of the U.S. Constitution originally, looking at Article 1, Sections 8, 9, and 10 of the Federal Constitution. It may help you as you follow through this segment today to have a copy of the United States Constitution available to you. I usually keep a small copy that you can get from the American Constitutional Society. And if you flip through that, as we go through the analysis of various sections of the federal Constitution, I think you might be able to follow this along much better. Later on, you'll probably want to print out the Florida Constitution so that you can follow our lectures on the very specific articles of the Florida Constitution and have a copy of that with you also as you review this series of lectures. But for today, we're going to try to look at the large principles of federal constitutional law that relate to the states, relate to how states are established, relate to what powers the federal government has and what powers the state government has. A lot of this is reviewing material that you've had already in your course in U.S. constitutional law. So let's begin with Article 1 of the U.S. Constitution. And I'm really quite sure that you've been made familiar with the large questions that are settled by Article 1. And I particularly want you to look at Article 1, Section 8, where the powers of the federal government are laid out and where it has the power to tax, to pay debts and so forth, the various fiscal powers, the power to borrow money. Here we find the Commerce Clause, the authority to regulate commerce with foreign powers among the states and with Indian tribes. Now, as we read through the Constitution, let's keep looking at these provisions relating to Indian tribes, because when we look, and later, a short time later, when we look at how the boundaries of Florida are defined, we're going to realize that that within these boundaries are certain territories that are given over to Indian tribes, Indian reservations, and those areas are not within the control of Florida government. They, according to federal law, based on the federal Constitution, are within the authority of the Indian tribes, the Seminole tribe, Miccosukee tribe, operating under the authority given those tribes by the U.S. Congress pursuant to the authority in the Constitution. And the power to regulate commerce, obviously this power of interstate commerce is used a great deal by the courts to set up the limits of state power. And ultimately, the U.S. Supreme Court finds not only a commerce power, but a dormant commerce power, a power that's implied because of the existence of other powers. And we'll look at that a little bit more closely in this lecture. The Congress gets the power to deal with the militia. And again, as you look at a map of Florida, think about those portions of Florida that are not under the control of the state government. There are sections of Florida that legislature cannot pass laws they're military installations, and those are governed by federal law, and that federal law exists and sanctioned by the Constitution, Article 1, Section 8. And then the necessary and proper clause, which has been used in a great number of opinions, including some early opinions that we'll look at quite soon. Now the limits on federal power. First of all, the limit on abolition of the slave trade. In the Constitution, as originally adopted, we don't talk about slavery, but we talk about that in a backhanded way. We talk about the slave trade, and we say that it can be abolished no earlier than 1807. And in fact, that's when slave trade was abolished. During the administration of Thomas Jefferson, who himself at one time had owned slaves, we abolished the slave trade. Curiously, that abolition was actually supported by the slave states, and as you go through the analysis there, you'll understand that some of the economics of owning slaves really made the abolition of slave trade to the economic advantage of some of the slave owners. Look, at the federal government may not suspend the writ of habeas corpus. This is the only writ from British common law that's in our Constitution. So there's a prohibition on its suspension. And the federal government, in Article 1, Section 9, before we get to the Bill of Rights, is prohibited from enacting bills of attainder or ex post facto laws. Section 9 prohibits the preference among states. And Section 10, limitations on states. Look at the repetition. Under Article 1, Section 10, again, before we reach the Federal Bill of Rights, the federal Constitution says that the states may not enact bills of attainder or ex post facto laws or laws impairing the obligation of contract. So when we look at a state constitution, Article 1 of the state constitution, which is our Declaration of Rights, we'll find some of these same provisions. But do note that whether they were contained in the Florida Constitution or not, they've already been prohibited by the federal Constitution in Article 1, Section 10. The Constitution prohibits laws imposing duties on exports or imports unless Congress gives its consent. And unless Congress consents, no duty or tonnage, establishment of an Army, Navy, or an agreement with any other state or foreign power. Now note that agreement with other states. Later in the course, we'll deal with the question of interstate compacts. Florida has several of these interstate compacts, agreements with other states. Those are adopted pursuant to authorization from a congressional act. So under Article 1, Section 10, congressional approval is necessary before one state enters into a contract with another state. Let's go to privileges and immunities. We're going to find this language in two portions of the federal Constitution. First of all, in Article 4, Section 2. And later, when we look at the 14th Amendment, we'll find it again. So privileges and immunities. Now, what does this mean, and from whence is it derived? First of all, the idea of privileges and immunities was incorporated in a number of the royal charters. Privileges and immunities is very specifically laid out in the Articles of Confederation. So the concept of privileges and immunities actually precedes the adoption of the federal Constitution, and it becomes a very important principle And I want you to think about privileges and immunities. Why was this provision included in the original colonial charters? And it's because when you're trying to talk people into leaving the comfort of England, such as it was at the time, you now need to give them assurances that they're going to have the privileges that Englishmen have, that they're not leaving behind the rule of law on which they came to rely so thoroughly. And if they go to the state, to the colonies, before they were even a state, they want to be sure that they're going to be treated as other people are treated. So it's a matter of equal treatment. And it applied originally to the people who were coming to the colonies before we're even a nation. So as you think about that in modern terms, think about somebody coming from New Jersey to Florida. Are they going to get the same privileges and immunities as Floridians do? As we get further in this course, particularly when we get to the issue of ad valorem taxation, we will come to doubt whether privileges and immunities are actually being enforced in the way that it was originally intended in our Constitution. Article 5, Article 4, Section 3, Clause 1 tells us how states can come into being. They may be admitted by Congress, and this becomes very important for Florida later on. As we look quite early in the Florida Constitution at Article 2 of the state constitution, laying out general principles, we're going to find that the boundaries of our state exist in a unique way, in part because our boundaries were spelled out in the Florida Constitution of 1868, and when the federal Congress approved our admission to the Union, or readmission to the Union, in approving Florida reentry under a constitution which laid out certain boundaries. Those boundaries came to control, and they're beyond the traditional boundaries and beyond the boundaries of other states that are adjoin Florida. And we'll look at that when we get to Article 2 of the state constitution. Congress has control over the admission of states, and they admit states in accordance with the terms. There's a great deal of law relating to admission of states, and some of it is very interesting. There was a time back when President Taft refused to agree to a law that was admitting Arizona and New Mexico because those states had adopted judicial recall. That is, the power of the people to call judges into account for decisions they had made. And President Taft, properly, in my judgment, decided that was not consistent with the principles of the federal Constitution and vetoed those provisions. It was only after they had been amended and the admission brought back to Congress for redecision that New Mexico and Arizona were admitted. Article 4, Section 4 really interests me a great deal, but I must confess that if you look through our jurisprudence, you're not going to find very much in way of construction of this. You won't find any large development of the principle of a Republican form of government. And so we're left to guess what it might mean in various contexts. As I've thought back on the really important cases that were the cases that required one man, one vote, beginning with Baker versus Carr, I've often thought that though those cases were decided on equal protection grounds. We might have been better off had the U.S. Supreme Court gone to the Republican form of government as at least an additional ground for deciding those cases. But today, we have a part of the federal Constitution that sets out a large principle governing the states, and we don't entirely know what it means, but we're left to guess. And my guess is that your generation of lawyers may see some further development of the principles of a Republican form of government, and that this principle may very well call into question some provisions of the Florida Constitution, particularly those provisions which put limitations on future legislatures from taking certain kinds of action. We will deal with those sections when we get to them in our review of the Florida Constitution. The Supremacy Clause, we're all familiar with the Supremacy Clause, but it may mislead us. Think about the very specific words of the Constitution. The Constitution, the laws of the United States, which will be made in pursuance thereof, and the treaties made. I want to linger on treaties. I have a client, hypothetically, actually, historically. I've had several clients who were wrongfully imprisoned. They were actually innocent, as later demonstrated by DNA testing. And so they were imprisoned for crimes they did not commit. There is a treaty entered into by the United States, ratified by a 2/3 vote of the United States Senate, and it says that the International Convention on Civil and Political Rights will be a treaty of the United States. One of the provisions in that treaty says that if anybody has been improperly detained or imprisoned, they'll be entitled to compensation. So when I have a case where somebody's been actually innocent but has been in prison for, say, 27 years, can I turn to the International Convention on Civil and Political Rights and say to the courts, we now have adopted a treaty. It's part of our fundamental law because of the Supremacy Clause, and I now can receive compensation? The answer is no. The United States Supreme Court has consistently held that where a treaty does not have all the terms necessary for its enforcement, it is not self-executing. Now remember that phrase, self-executing. We'll come into contact with that phrase again in state constitutional law where it has significance as well. But because the International Convention on Civil and Political Rights is not self-executing, then it's going to take an act of Congress or acts of the legislature to bring that right into existence in a way that citizens can actually rely on that right for its enforcement. Now let's go through the Bill of Rights. Let me ask the general question that you should be able to answer, and that question is, which of the guarantees in the Federal Bill of Rights have been incorporated against the state? The answer, as you know, is that most of them have been, but we'll have to walk through them one by one sometime later to talk about those. And I propose that let's put that off until we get to an examination of the Florida Constitution, Article 1, Declaration of Rights. We should pause at least to look at the 9th Amendment, a guarantee that the enunciation of certain rights shall not be construed to deny or disparage others retained by the people. And again, that has been treated by the courts as a truism, and we don't have much jurisprudence that is important. The 10th Amendment however, is an amendment that we have some cases on, and you'll recognize the 10th Amendment as fundamental to the way that powers are allocated between the states and federal government. And the 11th Amendment becomes important again on such issues as interstate compacts. Hypothetically, not hypothetically, actually, Florida has entered into an agreement with the states of Alabama and Georgia relating to a river system, the Apalachicola Chattahoochee Flint River System. And so there are disputes about who gets the water in that system. The Interstate Compact has been an attempt to try to resolve issues of water allocation, but that has not worked fully. And so when that compact is not working properly, what remedy does the state have? State has to sue another state only before the United States Supreme Court. It may not, it may not achieve certain kinds of remedies because of the 11th Amendment. Let's go through the Reconstruction Amendments. The amendments were adopted after the federal government abandoned Reconstruction. Of course, the abolition of slavery is important to us. The 14th Amendment is extremely important to us. Again, we find the phrase privileges and immunities, as we found back in Article 4 of the Constitution. But in the 14th Amendment, we find it again, and we also find the application to the states of equal protection. So equal protection enters our constitutional fabric in the 14th Amendment and becomes extremely important to an examination of the exercise of state powers. There are election amendments, amendments relating to the power of people who've been in previous condition of servitude to vote, the direct election of senators, women's suffrage, and prohibition of poll tax, an amendment which was sponsored by a Florida senator named Special Holland, and then 18-year voting. So federal voting rights are spelled out in this series of election amendments. And then there are amendments that relate to the sale of alcohol. And this is a very interesting area for students of state constitutional law. First of all, the federal government adopted the 18th Amendment. It was in place for a while, which has actually prohibited all alcohol sales, state and federal. And then the 21st Amendment repealed the 18th Amendment and left the regulation in the hands of states with a very specific provision that importation into states in violation of state laws was prohibited. Now, we have in Florida the concept not only of a dry state, but in some counties, county option. For a long period of time, Leon County was a dry county. It took a vote of the people of Leon County to allow the sale of alcohol either in bars or in beverage stores or grocery stores. There are some counties in Florida, in my last count, there were 4 or 5 that were still in one way or another dry counties that prohibited the sale of alcohol. So we've now moved from federal regulation to state regulation, and the state has given to local government the county option to allow or to disallow the sale of alcohol. So as you pass through Madison County, and you today in 2013, and you stay at a hotel, have a meal, don't try to order a cocktail with your meal. I don't think you'll get it. Okay. I think it's useful now to go back and look at some of the important cases that you studied in federal constitutional law. Now, this will not be comprehensive in any way, but you need to be aware of these cases and have them very high in your memory as you go through the study of state constitutional law. I'd like to look, first of all, at a couple of cases that were handed down by Chief Justice Marshall, McCullough versus Maryland in 1819, Gibbons versus Ogden in 1824, and a case decided after Marshall left the court, Cooley versus Board of Wardens in 1851. Okay, the two Marshall opinions, McCullough versus Maryland, and Gibbons versus Ogden. In McCullough versus Maryland, you may very well remember that the government was dealing with issue of banking, and you will remember that the question of whether the federal government should have a bank was very much a hot political issue of the times, extended on into 1828 and beyond, where there was some question about the power of bankers. And you'll find traces of this in the first Florida Constitution. But before Florida was in a state and became a state, in fact, before it became a territory, Justice Marshall decided McCullough versus Maryland, in which it contained that famous line, "The power to tax is the power to destroy," and held that the establishment of a bank was within the federal authority, and that since the federal government was operating within its constitutional authority, the state had no authority to intrude into the banking law and could not tax a federal bank. Gibbons versus Ogden was that famous navigation case decided in 1824. Ogden had a New York monopoly to run a steamboat ferry between New York and New Jersey, and Gibbons obtained a federal license, and so the conflict is now between a state monopoly and a federal license. And so we've got a very clear issue relating to Commerce Clause, and here we see strong hints of the possible development of a dormant Commerce Clause. That is, the implication that because a certain area had to clearly lie within the realm of federal jurisdiction, then any poaching on that system of regulation by the states would be a violation of the Dormant Commerce Clause. A case decided after Marshall left the court was Cooley versus Board of Wardens, and this is dealt with a law that Pennsylvania required any vessel navigating Pennsylvania waters to pay into a fund to take care of distressed and decayed pilots, even if no pilot was used by the vessel. It was held that where the Commerce Clause requires a general rule, the state does not have the power to act. Commerce power is granted to Congress, or some state legislation where subjects are in their nature national. So commerce becomes very, very important to us as a source of federal power, and thereby a limitation on state power. And we might now walk through some of the cases just to review the cases that have dealt with the Commerce Clause. Remember that the United States Supreme Court used the Commerce Clause to prohibit the development of child labor laws in its 1918 decision. The so-called sick chicken case decided in 1935 invalidated wage and hour laws. And then we began to see a shift in the decisions by the United States Supreme Court. Important among these decisions was the Jones and Laughlin Steel Corporation case, which set forth new standards for analysis of the Commerce Clause. Wickard versus Filburn, the 1942 case, is one of the cases that just greatly expanded the Commerce Clause, because we now have regulation of a farmer who is growing crops. The crops are not sold to anyone else. They're just used as feed for his own animals. And yet the United States Supreme Court upheld regulations restricting the amount of crops that could be grown, and did that under the analysis that by a farmer growing his own crops for feed, he thereby was taking away from the marketplace, and therefore that had an impact on commerce. It is way out on the frontier of these cases under the Commerce Clause. And then Katzenbach versus McCullough in 1964 dealt with the public accommodations provision in the Civil Rights Act. And here we dealt with a restaurant that did not cater to interstate commerce. It dealt with largely with local clientele, and yet the federal law was applied to assure that access to this public restaurant was provided by the Civil Rights Act provisions in terms of public accommodation. So that upheld federal law that was very important for the development of civil rights in this country. Garcia versus San Antonio Metropolitan Transit Authority upheld the application of the Fair Labor Standards to employees of a municipal facility operation. And then I'd like to go briefly to a series of cases that relate to the idea of privileges and immunities and relate to the scope of federal authority versus state authority. And our first case is New York versus United States, where federal legislation dealing with retroactive waste was invalidated. Federal law that said how radioactive waste was to be disposed of was invalidated because it intruded into New York. It was telling New York how it had to dispose of radioactive waste. Again, this is the beginning of a series of cases that become very, very important for analysis of the relationship between state and federal governments. U.S. versus Lopez said that, again, Congress was without power under the Commerce Clause to enact legislation to prohibit anyone from knowingly possessing a firearm in a school zone. Part of the analysis in Lopez was that the federal legislation required local law enforcement officers, sheriffs and police officials, to enforce the law. And the Lopez decision said that the federal government may not commandeer, federal government may not take over and give directions to local law enforcement officials, because that would intrude into the federal system where local officials got their instructions from state and local officials. And then the Prince decision, the court directly struck down the Brady handgun legislation. And again, the Prince case dealt really quite specifically with the principle I talked about in analyzing Lopez. Prince was the case that dealt with the commandeering idea, and so we begin to see the U.S. Supreme Court being skeptical about the exercise of federal power. And now a few other cases to look at. And these cases really derive from the 11th Amendment. Ex parte Young is a case that is still quoted quite frequently. It says that although you may not sue other states, you may sue state officials for injunctive relief. So if state officials are doing something contrary to the federal Constitution, you may sue them seeking an injunction. Question of damages is a different question, but injunctive action will be allowed. Seminole Tribe versus Florida, again, an important case. A sharply divided court, 5-4, decided that earlier decisions which upheld congressional authority to allow monetary remedies against the states were inconsistent with the 11th Amendment. So the Seminole Tribe of Florida was a victory for the states. In Maine, Ogden versus Maine, 1999 case, again, we dealt with the Fair Labor Standards Act, a case brought by Maine, against Maine by a state employee. And in that case, the court held that the Seminole Tribe immunity carried over to the state courts. We should note that the ex parte Young principles allowing injunction are still in place, but the damage action under Ogden versus Maine are not allowed. Kimmel versus Florida Board of Regents is a case arising from Florida State University. Kimmel was a professor at FSU at a time when I was president of FSU, so it was a case against me, I guess. It's a case in which Kimmel sought protection under federal age discrimination and sought damages against Florida State University. Case is somewhat more complicated, but ultimately the United States Supreme Court held that Kimmel could not bring his damage action against the state university. A little bit about spending powers, and I'm going to touch on South Dakota versus Dole. Spending powers have been used on a number of occasions to justify the enactment of federal law and federal regulations, which somehow relate to federal appropriations. And so in South Dakota versus Dole, we're dealing with provisions in the federal law that relate to the idea that if you accept federal highway money, you have to enact certain laws. Again, think about, in South Dakota versus Dole, think about the concept of federal intrusion into state power. And so South Dakota versus Dole laid out a series of principles that we might examine as we look at the issues of the use of spending power. First of all, legislation advances the general welfare. Congress acts in an unambiguous way. there's no independent constitutional principle preventing the act, and conditions are reasonably calculated to advance the federal interest. And so those are the tests that you use when we look at the spending power. Dormant Commerce Clause, again, a quick review of these cases. You'll remember them, I'm sure, from federal constitutional law. Pike versus Christ Church set forth a balancing test for non-discrimination that has a possible, where the state legislation has a possible impact on interstate commerce. Brown Forman Distillers versus New York dealt with sort of a most favored nation provision in the beverage law of New York, and New York law fell. The Westland Creamery versus Healy case in 1994 held that legislation that discriminates against interstate commerce is invalid, and the City of Philadelphia versus New Jersey case held that a New Jersey statute prohibiting solid waste disposal in state landfills violated the Dormant Commerce Clause. So this City of Philadelphia versus New Jersey might be looked at in comparison with the New York case we looked at earlier. We're dealing with landfills, with disposable of the disposition of waste, and here the United States Supreme Court says that New Jersey may not prohibit interstate commerce, which includes waste disposal. And now a couple of cases, several cases that deal with the Privileges and Immunities Clause, and these come up in very interesting context. I think maybe the most interesting might be the Zobel case. Zobel was the case that invalidated an Alaska plan to take the revenues that came from drilling permits for oil, which were very substantial revenue, and to distribute those revenues to Alaskan citizens. But the distribution plan called for greater distribution to those people who lived in Alaska for a longer period of time. And so therefore someone who had just moved to Alaska did not get the same benefits as someone who lived in Alaska for, say, 5 or 10 years. And so the United States Supreme Court in 1982 struck down this Alaska plan. It was, the majority opinion was based on equal protection grounds, but the concurring opinion by Justice Sandra Day O'Connor explicitly put forward the idea of privileges and immunities in this context. The earlier case of Shapiro versus Thompson held unconstitutional. District of Columbia law denying welfare assistance to residents of the state who had not resided within their jurisdiction for at least 1 year. And this applied not only to the District of Columbia, but to other states that were involved in this consolidated case. Sayers versus Roe, 1999 case, was dealt with the California law. California and tried to enact a law that said that people could not receive welfare benefits unless they had been in the state for a certain period of time. And again, the United States Supreme Court used privileges and immunities to invalidate the California law. Finally, Norlinger versus Hahn, a 1992 case, upheld Proposition 13 in California, a provision that assesses taxable property value and the time of purchase. So if you purchase at an earlier date before inflation hits the real estate market, your assessment is based on your purchase price. But if you come to the state later and purchase property, again, your assessment is going to be based under this California scheme on the higher price that you paid for your property. And therefore, there is a discrimination in the law that exists between people who were early purchasers and those people who purchased in a later inflated real estate market, even though the properties themselves may be exactly the same. The United States Supreme Court reviewed this under equal protection grounds and found it valid. I think it was a terrible mistake. It also did not address the privileges immunities case for technical reasons, and so we have the Norlinger case standing in a position that really sets up a barrier to the further application of these important federal constitutional principles to state government. And they've allowed Florida to modify its own very good property tax laws and put in principles of inequality into our law, much to my displeasure. And I hope when we get to that subject, you'll understand what has happened to Florida law and why it's not only unwise but should be reviewed for constitutional infirmity. I mentioned earlier the Republican form of government. It actually appears in Article 4, Section 4. The only case we've got, a significant case we've got, is from Oregon, a case decided in 1912, and it held that forms of direct democracy, where people get to vote directly and not through their representatives, is not in violation of the Republican form of government provision in our federal Constitution. As I've said, my hunch is that you're going to have to deal with this further as you advance in law practice. Supremacy clause we've discussed. I now want to talk about several principles that help protect federalism. First of all, I want to remind you of a case which I'm quite certain you analyzed when you studied federal constitutional law, and it's the case of Robbins versus Pruneyard Shopping Center. It was a Rehnquist decision, and you'll probably recall that this Rehnquist decision came down in the context of free speech. A series of federal cases had held that it was not a violation of the federal First Amendment for private property owners to announce that they would not allow the distribution of leaflets on their property. And this applied to large shopping malls and other facilities that seem to have a sort of a public openness to them. But despite the fact that the public was invited to these places where they were privately owned, the private owner could, under federal law, restrict the distribution of leaflets or other kinds of speech within the property that they owned. Now, California came down and made a decision in a case relating to Pruneyard Shopping Center in California. And the California case ultimately held that under the California Constitution, the free speech principles were larger than those under the federal Constitution. And in California, because of the California Constitution, free speech trumped private property. And so the California court reaches a result directly contrary to the result reached by the United States Supreme Court. And when that case gets before the United States Supreme Court for review, Justice Rehnquist holds that the California decision, based on the California Constitution, now is upheld, and that now sets up a very important principle, one that we'll look at in more detail in this course, but a very important principle that allows the states to interpret their own constitution in many areas of constitutional law to make it larger than the federal Constitution. And that alone, that principle alone, will justify your study of state constitutional law. There are also other principles that protect federalism, the requirement that state remedies be exhausted, a principle that applies in a number of cases, including capital punishment cases, the principle of comity, that's C-O-M-I-T-Y. Comity actually says that the federal courts will try to pay attention to what the state courts are saying and try to respect the statements of state courts. And the principle of comity will frequently be invoked by federal courts to say that they're not going to in any way displace a state court decision. The idea of abstention, again, that's something you'll look at in federal civil procedure in detail, but there are instances where federal courts will use principles that say that they will abstain from taking on a case because it properly lies within the jurisdiction of the state. And then there's authority in the Florida Constitution in Article 5 allowing the United States Supreme Court and the federal appellate courts to certify cases to the Florida Supreme Court for decision. So when encountering a Florida constitutional question, for instance, or any question relating to Florida law, substantive Florida law, the federal courts may refer the decision to the state court, and the state Supreme Court has discretion about whether to take up that case or not. I don't know of a single instance where the state court has refused to take on a question certified by the federal appellate court of the United States Supreme Court. I now want to just mention two cases that relate to the separation of powers between the federal government and the state government. And one of these cases, a case that I handled back in 1963 when I was first beginning practice. And I will during this course a number of times refer to cases that I've handled, and I do that for a couple of reasons. One, I enjoy telling the story, and number two, I think it'll give you some idea that lawyers who are in practice do encounter these principles of federal and state constitutional law in ways that do affect their clients. Now, in my case, it related to a contract with the Federal Department of Defense. Following the Cuban Missile Crisis of 1962, the federal government established a number of new facilities in the Keys, and these included a large radar installation in one of the keys named Cudjoe Key. But there were no barracks at Cudjoe Key. And so to move the people who were manning the radar facility at Cudjoe Key, the Department of Defense put out a request for contract and allowed companies to bid for the transportation contract to move troops from Key West to Cudjoe Key and back to Key West. And so Gray Line Sightseeing won that contract and began to transport troops from Key West to Cudjoe Key. They ran into the problem of the Florida Public Service Commission. And Florida Public Service Commission cited Gray Line Sightseeing because it did not have permission from the federal public service, from the state Public Service Commission to engage in this transportation for hire between Key West and Cudjoe Key. In other words, they did not have a certificate of necessity and convenience to move one place to the other. So the case gets before the state courts and comes before a state Supreme Court where there is a justice named Millard Caldwell, who is a fascinating character. He had been first a congressman, had been elected as governor of Florida, been a congressman from West Florida, elected governor of Florida. After leaving the governor's office, he was appointed to the Florida Supreme Court and was serving in the Florida Supreme Court. He was a major advocate for states' rights. He was a person who, when you looked at constitutional issues, you think that it almost would always come down on the side of the states. And so, as a young lawyer going before the Florida Supreme Court, as I began to think about what justices are likely to be on my side and what justices are likely to be on the other side, I counted Millard Caldwell at the very top of the list of judges who are most likely to be opposed to my position. And yet, when the decision was handed down, Millard Caldwell squarely said that Florida has no authority to intrude into a contract granted by the federal government to a private company. And he entirely upheld my position. The point I want to make here, in part, is a practice point. Don't assume that because a judge has a certain background or has made certain extrajudicial statements that the judge is going to be against you. I was saved in that case by the fact that Justice Caldwell came down on my side, and when he did, the whole court came with him. So I got a unanimous decision in that 1963 case. I now want to move forward to a case somewhat more current, decision in Odebrecht Construction versus Florida DOT, decided by the 11th Circuit in 2013. In Odebrecht, there was a Florida statute which prohibited any company that is doing business with Cuba from doing business with the state of Florida. Now, the act was drawn in a very broad way. It said not only any company that did business with Cuba, but any company that was affiliated with a company that did business in Cuba. And Odebrecht did not do business in Cuba, but did a very substantial amount of construction business for the Florida Department of Transportation. And a affiliated company to Odebrecht did business in Cuba, and so to make sure that the barrier was not applied to them, they sued, and the court upheld the position that where state law conflicts with federal law, and that federal law is enacted pursuant to the federal Constitution, then the state law must fall. And it also pointed out that the president and the Congress acted at the zenith of their power when acting pursuant to the authority to direct economic policy toward Cuba. So Florida has to get out of the foreign relations business and leave that to the federal government where the U.S. Constitution assigned it. And the Florida statute was invalidated. I think that will wrap up our discussion of federal constitutional principles, and we can next move to the Florida Constitution, look at it in some detail, beginning with the history of the Florida Constitution and moving on to the general principles of the Florida Constitution, and very soon into amendments and the various substantive portions of the Florida Constitution. But throughout this, keep in mind the large shadow that the federal government and the powers granted to the federal government cast over state action, and the state legislature must pay attention to the scope and the reach of federal authority. You may not enact laws that impact companies who are trading with Cuba. You may not establish administrative rules which would tend to sweep aside federal contracts from the Department of Defense. And so these federal principles are always controlling to us, and we look at them again in context of very specific issues which will be raised in the following sessions. Thank you.